If any of this sounds familiar, you're going to want to stick around. Maybe you've just found out your business partner's been dipping into the company account, using funds for their own personal stuff without your okay. Or you've sent someone money by mistake, and now they're refusing to give it back. Or worse, you've got evidence that someone who owes you money is quickly selling off their assets, property, vehicles, anything, just to stay one step ahead before you can take legal action. You might need to freeze their accounts. You might need to stop those assets from disappearing altogether. If you're a creditor, or even just someone worried that the other side is trying to vanish their assets before a court gets involved, then this video is 100% for you. I'm Damin Murdock, principal lawyer at Leo Lawyers. You may already know me, or this is the first time you have visited our website or video library. Although this looks like me and sounds like me, this is my AI avatar presenting this video using the script that I have written and approved. At Leo Lawyers, we assist clients to take urgent court action to obtain injunctions and freezing orders. A freezing order is a powerful, fast, and court-enforceable remedy to maintain the status quo and preserve assets until the outcome of a final court decision. And in this video, we explain the process of how to apply for a freezing order. So you've just discovered something serious. Maybe a business partner has started moving money, or a person who owes you is suddenly getting rid of assets. If you're worried those funds or assets will vanish before you can take legal action, then applying for a freezing order might be your best next step. A freezing order is a court order that stops someone from dealing with certain assets like cash in a bank account, shares, or even property until a legal dispute is resolved. It's all about preserving the status quo, so there's something left to claim at the end of your case. First, your lawyer will file what's called an originating application in the Supreme Court. This outlines the interim orders, what you want frozen now, and the final orders you're aiming for. Alongside that, your lawyer will prepare a supporting affidavit. This is where you explain the background, what happened, why you're concerned, and why urgent intervention is needed. You'll also need to provide legal submissions that show two things: that you've got a prima facie case, which means a sufficient likelihood of success to justify, in the circumstances, the preservation of the status quo pending the trial, and that there's a balance of convenience. That is, the harm to you if the order isn't granted outweighs inconvenience to the other side. The court takes urgency seriously. Usually you need to act within 7 days of discovering the issue. If you wait too long, your chances of getting an order drop significantly. That's why it's important to pull together a chronological outline of events as soon as possible. Include screenshots, emails, anything that supports your concern that the assets might disappear. Often, these orders are granted ex parte, which means the other side doesn't get notice right away. That's because giving notice might lead them to move the assets before the court can step in. If the judge agrees, you'll get interim freezing orders, then you have to serve those orders on the other party. They'll usually get 2 to 5 business days to respond. At the return hearing, the court decides whether to keep the freeze in place or lift it. If it's extended, the next step is to file a formal statement of claim. This sets out the legal grounds for your case, like breach of director duties, misappropriation of funds, or breach of contract. From there, it moves into the standard litigation process. The other party files a defense, you exchange more evidence, maybe go to mediation, and if that doesn't work, the case goes to a final hearing. If you want a full breakdown of how litigation works, we've got a separate video walking you through that step by step. Let's talk about costs, because that's something most people want to know up front. Applying for a freezing order or injunction isn't a simple task, And it's not cheap. You'll need a lawyer to draft all the key documents. That includes the originating application, the affidavit laying out your evidence, your legal submissions, and the actual court orders you're asking the judge to make. On top of that, you'll usually need both a solicitor and a barrister to prepare and appear at court, not just for the initial urgent hearing, but for the return hearing too. And that's just to get the freezing orders in place. Realistically, you're looking at somewhere between $25,000 and $40,000 plus GST just to obtain the freezing orders, not including the cost of any litigation that follows after. Yes, it's a serious investment, but if you're at risk of losing access to funds or assets completely, it may be a necessary one to protect your legal rights. So if you're in a situation where assets are at risk of disappearing, whether it's money, shares, or property, don't wait until it's too late. Freezing orders are powerful, and the sooner you act, the better. If you think you might need urgent legal help or just want to understand your options, reach out to us. We'll walk you through what's involved and help you figure out the next best step. Thanks for watching. And if you found this helpful, feel free to share it with someone who might need it.